Yes, your lordship. Lordship, with the consent of other side, my lord, I beg to mention item number
A bit
15.
louder.
With the consent of other side, my lord, I beg to mention item number 15, my lord.
15.
Good, some personal difficulty and suffering from neck pain, my lord.
Okay.
After vacation, my lord.
We have filed our
Mr.
objection,
A.
Lordship. We have filed our
Mubarak, learned counsel for the I do applicant has sought an adjournment on the ground of partial difficulty on his part. Full stop. S.H. Vora, learned additional public prosecutor for the respondent state is present. Full stop. In view of the affair, so need comma release the case after the ensuing summer vacation, comma as paid for.
May I please, your lordship? Your lordship, I beg to mention for listing of Met appeal, your lordship.
Orders.
Hearing, your lordship.
Or
Actually- Yes, your lordship. Actually, what has happened, your lordship, because of this Met appeal, your lordship, the respondent, your lordship, actually, he is not getting his pensionary benefit, your lordship. There's from the.
For hearing, Mr. Counsel, you have to either make an application before the AST or file an IA.
May it please the lordship. Lordship, I beg to mention a criminal appeal for listing lordship.
Or,
Listing lordship.
or what?
Orders lordship. Matter
Maybe
will be
after
listed.
vacation? After
No,
vacation?
no lordship. This Friday.
For what purpose?
It was urgent.
What is the
lordship.
purpose?
Uh,
What is the purpose? Or why? What is the reason?
Reason lordship.
Yeah, since it was-
He was convicted under section 302, 305 and 448 of the.
That's all right.
Indian Code.
For what?
Sensitivity. Urgency.
Urgency lordship.
Come back with reason.
Next week lordship.
Come back with reason.
Okay.
It is for admission item number 1.
Jail appeal, Lordship.
Jail,
Yes, Lordship. Amicus curiae has to be appointed.
offense,
Lordship, paper book is not with us, Lordship.
something. Jail, accused, fine. Revision भी क्या करता है?
97.
6. 6. A criminal appeal from jail. Against the judgment. An order. 11/12/2023. Passed by the Learned Special Court, Dibrugarh. এইবোৰ একেই হ'ব
2, 3 and 4, Lordship.
also
That is not,
easier to
Lordship, the paper book is not with us.
tonight. Okay. Judgment tonight. This one, yes, sir. I go to Hegro. Office to appoint. I go to. This one. Go to office to appoint. Okay. Okay. Which I go to the office to appoint Devanga Kumar Boydo from the panel of amicus curiae for the accused to represent the accused appellant. I got video. It will give. This is an appeal from jail. This criminal appeal from jail is directed against judgment court. Wait, against the judgment and order dated 22/11/2023, passed by the learned session judge in sessions case number 135 of 2021. Posted up by the judgment and order dated 22/11/2023, the accused appellant has been convicted for the offense under section 302, and he has been sentenced to undergo rigorous imprisonment for life and to pay a fine of rupees 5,000, with default stipulation. First off, the appeal is admitted for hearing. The case records of sessions case number 135 of 2021 be called for Mr. or Mrs. Pardon me? Sophis. P. Mohanto, Pritam Mohanto is appointed. Pritam Mohanto from the panel of amicus curiae is appointed. Huh?
প্রীতম মহন্ত রেগুলার হয় না
Oh,
দেখা নাই
preliminary.
এনএনবি
Mr. NNB Chaudhary from the panel of amicus curiae to represent the accused appellant. Issue notice. Yes, Chris who appointed be furnished with the case papers. Issue notice returnable in 4 weeks. As MS S.H. Bora, learned additional public prosecutor, has appeared and accepted notice on behalf of the respondents. Issuance of formal notice is dispensed with. Full stop. Case record position. Please the case after 4 weeks.
It's not on the next day, Lordship. Yes, his name may be reflected in the.
Micah Spirit, so appointed, be reflected in the respondents in the college. Or be reflected in the call list. Both are going to click.
Item 3,
This is also jail appeal, Lordship.
Offense.
Paper
Three
book
zero
is
two.
not with us.
Go to इसमें लिखो अपनी Sessions Judge Dibrugarh, Sessions case number 100/2022, judgment and order dated 3/11/2023. Offense 302, Indian Penal Code, rigorous imprisonment for life and to pay a fine of rupees 5,000 with the false stipulation. Amicus curiae name. Rita Rasman.
Lordship, authorized.
item number 4,
In jail, Act number 2 is now. The judgment and order dated 10/10/2023. Use that. And take it as learned additional public prosecutor for the respondent number 1, State of Assam. The instant criminal appeal under section 374, (2) Code of Criminal Procedure is directed against the judgment and order judgment Judgment dated 22/02/2024 and an order on sentence dated 26/02/2024. Passed by the learned Sessions Judge Hailakandi in Sessions case number 10/2018. Posted by the judgment and order on sentence, the accused appellants have been convicted for the offenses under section 148/149/302 of the Indian Penal Code, and they have been sentenced to undergo imprisonment for 3 years under section 148 IPC for the offense under section, for the offenses under section 302/149, IPC. The accused appellants are sentenced to undergo rigorous imprisonment for life each and to pay a fine of ₹20,000 each, in default of payment of fine, to undergo further rigorous imprisonment for 1 year each. The sentences are ordered to run concurrently. The appeal is admitted for hearing. The case records of Sessions case number 10/2018 be called for. Issue notice returnable in 4 weeks. As Mr. Das, the additional public prosecutor, has appeared and accepted notice on behalf of respondent number 1, State of Assam. Issuance of formal notice stands this to the respondent number 1, State of Assam, stands dispensed with. However, extra copy. Accused appellants shall take steps for service of notice upon the respondent number 2 by registered post with AD as well as by usual process within 3 working days from today.
I also put the 3 notice.
Hi, Mr. D. Kothi. Counsel for the appellants. And Mr. Kekedas, learned additional public prosecutor for the opposite party number 1, State of Assam. This application of section 389(1) CRPC is preferred.
But in the petition, it is not written. In the petition, it is not written.
Seeking suspension of the execution of sentence passed against the accused appellant and for their release on bail. Full stop. The applicants as appellants, have preferred the accompanying appeals, criminal appeal number so and so against the judgment. Against the judgment and so and so, sentence issue notice returnable in 4 weeks. As Mr. Das has appeared, accepted, extra copy. The applicant's appellant shall take steps for service of notice upon the respondent number, opposite party number 2 by registered post with AD as well as by usual process. The learned additional public prosecutor may file the objection to the instant application on or before the returnable date.
For hearing item number 18.
S. Soma Hazurika, learned legal aid counsel for the accused applicant appellant, and Mr. K.K. Das, learned additional public prosecutor for the opposite party number 1, State of Assam. So Mr. Das, learned additional public prosecutor, has submitted on the basis of a report received by him from dated report dated 8/5/2024, received by him from the officer in charge, Morioni Police Station, that service of notice upon the opposite party number 2, informant,
Yes.
informant has been duly affected. None has appeared. For the opposite party number 2 informant, today on call, though the notice is seen to be served on 8/5/2024. The instant application, interlocutory application under Section 5 of the Limitation Act 1963 is preferred, seeking condonation of delay of 196 days in preferring the connected criminal appeal under Section 374(2) Code of Criminal Procedure against the judgment and order dated 23/02/2023 passed by the learned Special Judge Jorhat in special case number 29/2019 by the judgment and order dated 23/2/2023, the learned special judge has convicted the appellant.
Received the. Like
Lordship,
what?
yesterday we have filed our objection, Lordship.
Probably it
Perhaps
has not come on
not
record. my lord.
Lordship.
LCR call for has come, my lord.
She has come.
Yes, my lord.
Yes.
LCR I say. In cause list it is mentioned, my lord, and probably it is there.
Yes, when? Monday,
Lordship,
with the eye on record?
I has not come on record.
No.
Let the I-
Objection,
yes.
objection on record.
objection. no.
Mr. J. Kamar, learned senior counsel, assisted by Mr. P. Chaudhary, learned counsel for the appellants, and MS H. Bora, learned additional public prosecutor for the respondent state. Post of MH Bora has submitted that an objection to the interlocutory application has been filed yesterday by serving copies to the learned counsel for the applicant appellate. Post of Monday to not do no?
Lordship,
Monday,
Lord, she has some problem, so let
can
it be
it be
on
on Wednesday, Lordship?
Wednesday.
26, no?
26.
As the said objection filed on behalf of the state is not on record, office to trace out the same and list the state objection. Take the state objection with the case records. First up, as sought for by the learned counsel for the parties, list the case on Wednesday.
26. I do.
Much okay.
Meet, please, Your Lordship. Lordship, as per that Rule 10, we could not find any standing instructions. But I would like to point out certain things, my lord.
Lordship, I have rang the jailer, Lordship. I have asked the instruction.
Yes.
The jailer have said, Lordship, the psychiatrist is to visit him, Lordship, once in a month, Lordship, and he is not violent, Lordship. He used to get the medicine in proper time, and he is under control. But as it is a mental illness, Lordship, if they desire, and as I have asked for further instruction, they will ask for further instruction, whether he is to be sent to LCBT, Lordship.
No,
But
he
it's
has
not about desirability.
made
no,
submission On the basis of the provisions in the Mental Health Care Act.
My lord. Now, if I may like point out certain things, but an RTI was made actually regarding the review boards, mental health review boards. Your lordship comes to page, third page of that bunch. Now there's a table. Item number 2 in that table, my lord, Mental Health Review Board, Kamrup Metro. Its jurisdiction is Kamrup Metro, Morigaon, Nalbari and Karbi Anglong. So the district judge, Kamrup Metro, is the chairperson of this mental board. Now in a separate case, my lord, what has happened? A person was brought here. A mental, this board had sat, and he was there and referred to, if your lordship takes up this act, right, there's a something called halfway homes. Those are not per se hospitals, but they're midway certainly. The person was transferred there. In that case, I can pass on the order that was passed by the deed and mental board. In that case. Not, if your lordship takes up the paragraph 2 of that order, after due consideration, consultation, it is deemed fit to keep the patient incumbent at Help Aid and NGO for mentally ill person, Bamford Khetri, till his assessment at the Department of Psychiatry, Guwahati Medical College and Hospital. It is only after such assessment that the board shall reconvene and make decision for further course of action in so and so case. Accordingly, so and so was shifted to Help Aid and be produced tomorrow at GMCH for assessment. Now this assessment was done. Subsequently, he was sent to the same place. Now, it's not about my desirability, what section 103 says.
Doctor will say, lordship, they said that they will take another instruction, lordship.
Firstly, if we see the earlier report,
Which was sent by the board, lordship.
I think it is part of the
There is
report.
a green flag is there. I have what? Checked green flag.
It was by a medical board.
Lordship.
That is by Noga Medical College and Hospital.
Lordship.
He was examined on 7/6. But that board is not per se as part of
Mental review board. That is not person. Then either option is to get him appear before the mental review board here. And subsequently that the board has to take a decision. Anyway, he cannot, the law says shall be transferred to somewhere else, not prison.
You are referring to which section?
My lord, 103 in the main act. After the mention of the acts, it says directing the admission of a prisoner with mental illness into any suitable mental health establishment shall be sufficient authority for the admission of such person in such establishment to which such person may be lawfully transferred for care and treatment, provided that transfer of a prisoner with mental illness to a psychiatric ward in the medical wing of the prison shall be sufficient to meet requirements under this section. This is nowhere in any prison. provided further that where there is no provision for a psychiatric ward in the medical wing, prisoner may be transferred to a mental health establishment with prior permission of the board. My lord, if your lordship comes to subclause 6 of 103, the appropriate government shall set up mental health establishment in the medical wing of at least one prison in each state and union territory, and prisoners with mental illness may accordingly be referred to and cared for in the said mental health establishment. My lord, what has happened? This act falls under the Directorate of Social Welfare. There are no such establishments in jails, but there are certain NGOs under the Directorate of Social Welfare who runs this, and they are spread all over Assam. I have a list of them, if your lordship wants. And this list has been taken down from the website of Director of Social Welfare.
Regional sections. Regional sections. Instruction.
They will give us lordship, we need some time, lordship.
10 Rule 10.
Rule 10.
They will give us lordship, they are seeking some time, lordship.
Do you have any instruction?
I also could not find anything in the over the internet, because it says that if
But
shall-
procedure is laid down there.
Yes, ma'am.
Is
Procedure-
likely to be laid down.
Because it says shall, the outsider shall be in accordance with the instructions issued by the central government, as the case may be.
So central government must have issued something.
Instructions. We could not get hold of anything.
That could be a guidance for us.
Maybe.
In accordance with the instruction issued by the central government. Even if state government has not issued any instructions,
Central
central
government
government must have issued some instruction.
We could not get anything. I'm sorry because of that, but I think there is something, because in the earlier case, it has happened.
There has to be something.
Because the prisoners were transferred to certain homes or psychiatric wards of Tejpur. So it has happened.
And also the rules 11 also,
Rule 11
there
says.
is a guidance
Mm.
also. That mental health establishment referred to in subsection 7 of section 103 shall
Shall-
conform to the minimum
minimum
standard
standard.
and procedure as specified in the schedule. Your jail superintendent will not be able to do it. Inspector General of Prisons must have. That jail superintendent, you don't expect
So he's saying that lordship,
something positive from him.
so he's saying that he will ask the doctor lordship for
Doctor will
Doctor
not-
will not know.
that whether
That is
he is
question.
needed to send to Tejpur or not, lordship.
You are not asked to do so.
The law says we have.
Yeah. law-
You are requested to obtain the
Instruction.
standing instruction issued by
The central
either
government.
central government or state
State
government under Rule 10 of this mental healthcare right of persons with mental illness rules 2018. You have been requested to do that only. Your jail superintendent might not have the knowledge, but the Inspector General of Prisons might have the knowledge.
But so also maybe the Directorate of Social Welfare, because this entire thing falls under them.
I think Inspector General of Prisons, I think he is the head of the prison department.
Lordship. Through registry, Lordship.
What risk? You are not in touch with the Inspector General of Prisons.
I'll collect it. Lordship.
Huh?
I'll collect it.
Why you are shirking the responsibility?
No, Lordship. Lordship.
And in fact, the composition of the board also has district magistrate.
That I have seen. Deputy Commissioner and
Chairman is the
District
district judge, represented this district.
district judge is there.
He's the chairman.
When you are expected, can you say?
Minimum, Lordship, 1 week.
We are nearing vacation.
Because they will.
Friday. Friday is possible, Friday.
This Friday. Lordship, Tuesday, Lordship.
Tuesday. How about Tuesday? Read the previous order.
I have, this time
It's very
I have
specific.
sent to the jailer, Lordship, but I have sent the order,
First information he has provided
Lordship.
that regarding mental health
Illness.
review board functioning near the district jail Morigaon. Now it is Kamrup Metro. That is clear. Now next is what kind of standing instructions under
Rule 10.
subsection 2, section 103 and rule 10.
Lordship.
That is what we need
Prisoner,
from Inspector General of Prisons. Okay. Heard Mr. D.K. Bhattacharya, learned counsel for the applicant, and M.S.A. Beckham, learned additional public prosecutor for the opposite party number 1, state officer. Post. Mr. Bhattacharya, learned counsel for the applicant appellant.
Psychiatric ward in the medical wing of the prison shall be sufficient to meet the requirement under this section.
Information has been obtained under the Right to Information Act 2005 from the Mission Director, National Health Mission. Which is communicated by communication number so and so dated 16/11/2023. From the information so provided, comma. We have submitted that from the information so provided, comma. It is noticed that a mental health review board is functioning at Kamrup Metropolitan District for the jails. That's Kamrup Metro, comma Morigaon, comma Nolbari and Karbi Anglong. M.S. Begum has however submitted that instructions as regard information as regards extant instruction in terms of As may be prescribed. Prescribe মানে prescribe rules. Rules মানে rule 10. Rule 10 on a call explain instruction by central government or state government. Depending. In terms of subsection 2 of section 103 of the Mental Health Care Act 2017 and Rule 10 of the Mental Health Care within bracket rights of persons with mental illness bracket close rules 2018 is not yet obtained. Full stop. See, as MS Begum has submitted that a week's time be granted. So it should obtain the instruction from the Inspector General of Prisons, Assam. Full stop. As sought for by MS Begum, release the case on Tuesday.
25/6.
Objection.
One part of the information is received.
Lordship, other part I'll.
Other part, how to do it. Subsection 2 of section 103 is clear. Economic.
Item 16.
May I? My lord, the
এটা লিখে দিব। Respond number 1 state. Respond number 2 informant. As the case records from the learned trial court or from the trial court are not yet received from a office to issue a reminder to release the case after 3 weeks.
obligation.
Item number 17.
Made, please. So this, an appeal was filed under section 372 by the informant as an appellant. Now, the appellant during pendency of the appeal, the appellant died.
Appellant
Died. As a victim, he filed, he died. Now, there, the wife is there, deceased wife. She has filed an IA to allow him to proceed with the appeal.
Okay. Who was the earlier appellant?
Appellant was the father, Buddheshwar Soikia. He was,
Case is under POXO
no, Lordship, 302. The
302.
302. Respondent was acquitted from the charge under section 302.
Serious. Heard. Mr.
Gerald,
Gedalov,
Lordship.
learned counsel for the applicant and MS. Yes, you have any?
But two, Lordship.
2.
Sure, copy may be served to me.
Huh? Basically, he wants substitution.
Yes. To which I have no objection.
Huh?
I have no objection.
And the applicant falls in the category of
Because she is the wife.
hmm,
Is the wife. The applicant, she is the wife of the
near relative,
near
Near relative.
victim.
parent. Parent.
She had also suffered loss because husband died.
Buddheshwar
Wife
Soikia
of
was
the
the
deceased.
informant.
Yes,
And
but there was a victim.
yes, one
Victim
person
was-
died,
Victim was his,
the present applicant's husband.
no, Buddheshwar Soikia, he was the informant.
Informant was the
Right.
father of the deceased.
So present applicant is also the mother.
No,
Oh,
no,
wife.
is the wife, not wife of the Buddheshwar Soikia, but wife of the deceased,
Okay. Spouse,
spouse,
spouse.
Lordship.
Jada Longha, learned counsel for the applicant. MS A Begum, learned additional public prosecutor for the opposite party. Number 1, State of Assam, and MS M Bora, learned counsel for the opposite party number 2. Full stop. The instant application is preferred under section 394, Code of Criminal Procedure 1973. Leave to continue. Seeking leave to continue the accompanying appeal, criminal appeal number 433 stroke 2023, preferred to assail a judgment dated 11/9/2023 passed by the Court of Learned Sessions Judge Lakhimpur at North Lakhimpur in Sessions case number 22 within bracket NL of 2018 by the judgment dated 11/9/2023. The learned trial court had acquitted the accused therein, that is, the opposite party number 2 herein from the charge under section 302, Indian Penal Code. Full stop. Para. The accompanying appeal was preferred by Budheswar Soikia, who was the father of the
DG Simanto Pratim Soikia. DG Simanto Pratim Soikia, also informant of the case.
father of Simanto Pratim Soikia.
Lordship.
Simanto Pratim Soikia, for the date of which the trial of Sessions case number 22 within bracket NL stroke 2018 was held. Full stop. The connected appeal has been preferred under the proviso to section 372 CRPC. Full stop. The instant application has been, it is stated that the occasion to prefer the instant application has arisen as the appellant, Budheswar Soikia, has expired on
Lordship. Page 11, Lordship of the page 10 on 27/4/24.
27/04/2024. Full stop. A copy of the death certificate recording the date of Budheswar Soikia on 27/4/2024 and issued by the Department of Health and Family Welfare, a Bagaon Mini Primary Health Center, issued by the registrar within bracket birth and date under the Registration of Births and Deaths Act 1969 has been appended to this application. The applicant herein is the wife of late Simanto Pratim Soikia. Full stop. The applicant comes within the category of quote unquote near relative, being the spouse of late Simanto Pratim Soikia. Full stop. When did you file?
Lordship, on 7th of June. Three
30 days.
30 days. In case of conviction, appeal against conviction, there is no provision for appeal against acquittal, but Lordship have passed a judgment sitting with Justice Lordship Achinta Malla Borwa. In that judgment, Lordship has granted leave to to replace the appellant in case of acquittal also. Otherwise, 394 Lordship will find power given to substitute only in case of conviction only. I have the judgment, Lordship.
Conviction and sentence. Nine.
But yes,
So it has end of the termination. Spouse as provided in the explanation to section 394, CRPC, no? Mr. Alom. Mr. Alom. Counsel for the applicant has submitted that the connected appeal has been preferred under the proviso to section 372 CRPC. And the provision contained in section 394 CRPC speaks about a period of limitation in respect of an appeal preferred against a conviction and sentence of death or of imprisonment. Post up. He has referred to a judgment and order dated 22/11/2021 passed by a coordinate division bench of this court in IA criminal 472/2021 to submit that it has been held therein that the rigors contained in subsection 2 of section rigors contained in the proviso to subsection 2 of section 394 CRPC is not applicable in case of an appeal preferred by a victim, comma, defined in 2 within bracket WA bracket close of the code. Full stop. The learned counsel for the opposite parties have submitted that they have no objection if the instant interlocutory application is allowed. Full stop. By the judgment and order dated 22/12/2021, comma, it has been held by the coordinate division bench that the period of limitation comma provided in section 394 CRPC is not applicable in respect of an appeal which has been instituted under the proviso to section 372 CRPC. Full stop. Para. As the date of the appellant has occurred in on 27/4/2024 and the instant application is filed on 10/6/2024, comma, we are of the considered view that the instant application has been filed within a reasonable period of time. Full stop. The applicant herein has preferred the instant application seeking leave to pursue the appeal on the premise that the connected appeal has been preferred against the judgment of acquittal wherein the spouse of the applicant regarding the homicidal death of the spouse within bracket husband of the applicant, having regard to all the factors mentioned here in the book, comma, we deem it fit and proper to allow this application. First of office to carry out the necessary corrections in the cost title of the connected appeal, criminal appeal numbers.
Deeply applied.
For hearing item number 19.
medical কৰি দিম। আৰম্ভ কৰি দিওঁ আপুনি ক'ব কাট অফ টাইমটো
Lordship, on the last occasion, as regards number of PWs, I have checked, my lord. On 2416, 1 PW, on 2616, 2 witnesses, 19/7, 2 witnesses, 17/8, 2 witnesses, 35/17, 1 witness, then 31/5, IO present examine, 8/11 scientific officer.
Directly say
Then
whether
it will
the
be 10, my
appendix
lord.
is correct or not.
Lordship, it would be 10, whatever is there,
That's
10 witnesses.
all right.
Mr. Tiwari, এইটো এইখিনি মাৰিছে পল্লৱী Next question. Next question. ये वही जगह है। Mr. Sharma, you are waiting for the next item.
Yes.
We feel that it will not be reached.
No, because it is a jailable, 67-year-old man is in jail, my lord. In
No.
a very peculiar case.
No, we are delivering this judgment.
Yeah, I came to know it will take
So
time.
thereafter, we both have single benches also.
Then only can it be a fixed date, my lord, next week? Next week,
Next week, not
on 25th or.
possible next week. Hearing matters will be very difficult.
No, I
Already-
want a miscellaneous application, my lord, very short matter. I'll take only half an hour. Not even half an hour, 15 months.
The question is not only the hearing. To
Very
deliver,
I am minor, not a main case,
this is not for what
but it is listed together.
it is hearing column.
The hearing column, the main case.
Oh, I always. And otherwise also we give preference who are more in detention.
He is in detention, my lord.
But he is hardly 1 year.
No, over 1 year, about 2 years.
1 year, 3 months.
Yes.
We are giving preference to 6 years, 7 years, 8 years. That is,
Considering illness and.
that we have taken with a consciously with the permission of the Honorable Chief Justice.
It was listed many times and sometimes it is
What
hard.
to do? We are not.
Yes. So, my lord, there is an IA for additional evidence, my lord.
Huh?
IA for additional evidence, then it will go back to the again trial court.
No, if we allow only
Yes.
for that also,
For that.
law says that full scale hearing is needed to allow any kind of additional evidence
Yes.
under section 391.
391.
It is only after full scale hearing of the appeal. That is the law.
So I brought the distance also, my lord.
Huh? That is the law.
So, my lord, any day, my
For
lord.
allowing any application for additional appealance also, full scale hearing. It is
Yes.
not like a miscase for bail
My lord, then any fixed date, my lord, after vacation.
after vacation.
Hmm.
let us be reasonable all. After vacation, side you get a date.
17, any hearing day. 17, I think,
17,
17.
17 is Wednesday.
then 16 or
18,
19, 18 July.
Okay. Yes, Priya. R.P. Sharma, Learned Civil Council, assisted by Ms.
Edeka.
Adek, Learned Council for the appellant, and MS. P. Priya, Senior Counsel, Additional Public Prosecutor for the
And-
one state.
And Luptur
And you
Rahman.
were there, Mr.
In
LR
enrollment.
Majumdar, Learned Council for response number 2 are present. Post of, as sought for by the Learned Council Board of Parties, released the appeal on 18.
18 July
Seven.
for hearing.
Really? বললো भी नहीं নিও। কিবা correct করা তোমার। Mr. QR. Miss বলে কবো, হ্যাঁ? কবো। Run it. Amicus Curie. Appearing for the accused appellant has submitted that the prosecution has relied upon the circumstance of appearance of the accused in the police station on the date of occurrence with a dao in hand. Full stop. The prosecution has further relied upon an alleged confession made by the accused in the police station in the presence of the prosecution witnesses, PW1, PW2, PW3, and PW9. Full stop. It is his submission that neither such confession, alleged confession, is admissible in law, nor the factum of seizure of the dao, the alleged weapon of assault, neither the evidence regarding the factum was brought properly on record. He has further contended that the testimony of the prosecution witness, PW8, is doubtful. Full stop. It's not the case of the prosecution that the accused and the deceased were last seen together. Full stop. Since it is a case of circumstantial evidence only, there being no eyewitness, it was a duty of the prosecution to complete the chain of circumstances by admissible evidence. Full stop. He has contended that the alleged weapon of assault, dao, was not shown to the autopsy doctor PW6, who would have been in the best position to depose as to whether the injuries sustained by the deceased would have been possible by such kind of weapon. First, he has stressed on this aspect on the premise that the forensic evidence indicated that dao was very rusted. Full stop. It is further contended that one of the material witnesses, that is, the younger son of the deceased, was not examined by the prosecution. Full stop. Moreover, no witness from the neighborhood was examined by the prosecution. Full stop. The prosecution has relied simply on the forensic evidence of presence of human blood or human blood?
Human blood, my lord.
Huh?
Human blood.
Or simply blood?
Yes, my lord.
Where is the forensic?
My lord.
70?
76, my lord.
Human blood
Human blood.
of a particular group on the dao. And with the blood group taken out from the body of the deceased. These circumstances, according to him, is not sufficient for completing the chain of circumstances to bring home the charge of murder against the accused. Full stop. It is further pointed out, no, it is his further submission that when the circumstance of not seen together is not the case of the prosecution. There is no requirement on the part of the accused to provide any explanation under section 313 CRPC. Full stop. Merely submitting that the accused was adversely disposed towards the deceased and his younger son, comma, the prosecution cannot prove the case against the accused. Yes, anything more?
No, my lord.
That's all? Ms. Priya. Learned, additional public prosecutor. Appearing for the state has submitted that the appearance of the accused in the police station on the date of occurrence itself is a pointer towards involvement of the accused with the alleged date of his wife. Also, the place of occurrence was the house.
Yes, my lord.
House premises
House please.
was the premises belonging to the accused and the deceased. Full stop. The blood sample, the blood group taken from the deceased during the post-mortem examination had matched with the blood group found in the alleged weapon of assault, that is, the dao seized from the accused in the police station on the date of occurrence itself. Full stop. From the postmortem examination report, it is clearly demonstrated that the deceased died. Deceased met a homicidal death. Full stop. It is submitted that the accused had confessed the crime before the prosecution witnesses, PW1, PW2, PW3, and PW9.
It'll be 8, madam.
8,
Samuel.
9 in the police station. Full stop. Further, the accused had disclosed about committing of the crime to the prosecution witness, PW8 also. Full stop. The evidence laid by the prosecution during the trial were sufficient to bring home the charge of murder against the accused. It is. It has been contended that the chain of circumstances was not broken anywhere. As alleged by the defense. Full stop. MS Punya has thus submitted that from the evidence on record, only one conclusion can be drawn, and the same is regarding the guilt of the accused. Full stop. Para. The learned counsel for the parties have referred to a number of decisions in support of their respective contentions, and the decisions will be adverted to in the later part of the order. Full stop. Para. The learned counsel for the parties have fairly submitted that the plea of guilt appeared to have been made by the accused at the stage contemplated in section 229 CRPC has not been taken into consideration by the learned trial court to reach the finding on guilt on the charge of murder against the accused. Full stop. And the case that the instant appeal is to be considered on the basis of the evidence stroke materials on record, notwithstanding such situation. Para. It is necessary to advert to, at first, regarding the finding regarding the discovery of the dead body of the deceased Mrinali Urangia. Who are the witnesses?
PW1 is the son, man.
PW3. PW3. PW1, PW2, Mukul Gogoi. was the president of Village Defense Party, PDP, of Abhoypur village. Full stop. In his testimony, PW2 stated that on the date of occurrence, he came to know from the villagers no, who was the first? Who had seen the body?
My lord, he was my lord. Sanjeev Sonwal, my lord. PW,
4.
yes, my lord.
Okay.
Page 15.
PW4, Sanjeev Sunwal alias Bhai is a co-villager of the accused and the deceased. Full stop. On the incident, PW4 stated that at about 12 noon on the date of occurrence, he was playing football in Abhoypur, in the playground of Abhoypur village, which was near the house of the accused and the deceased. Full stop. When the game was over at about 12:30 a.m., he went to the house of Moina Orangia, that is, the younger son of the accused and the deceased, to drink water. Full stop. When he went to the back of the house of Moina Orangia to urinate, he saw a body of a woman lying in the back side of the house. Full stop. Noticing the body, he immediately informed Moina Orangia. Full stop. Moina Orangia then came to the place immediately and told that the woman was his mother. Body was of his mother. Full stop. According to PW4, blood was oozing out from the hand of Minali Orangia. Full stop. Then Moina Orangia informed the neighbors about the incident. Full stop. Mr. Mukut Gugoi, PW2, Mr. Mukut Gugoi, was the president of the Village Defense Party of Abhoypur village. Full stop. In his testimony, PW2 stated that he was informed by the villagers about the alleged killing of Minali Orangia by the accused in his house. Full stop. On receipt of the information, he proceeded to the house of the accused and saw the dead body of Minali Orangia lying in the house compound of the accused. full stop. Then, comma, he, within bracket PW4, immediately informed the matter to Namrup Police Station. Full stop. Software. The general diary entry number 98. There is another general entry. Okay, 88, 82. 82. 88, dated 4/10/2015, comma, exhibited as EXT 13, comma, was recorded at 12:27 PM on 4/11/2015. 4/10/2015. Full stop. As per EXT 13 GD entry number 88, comma, PW2 Mukut Gogoi informed telephonically at the police station that the accused had killed his wife by hacking her with a dao. Full stop. Upon receipt of the information, comma, the same was entered in the general diary and the charge of investigation was entrusted to the IO within bracket PW 13. Full stop. The
PW9, my lord.
prosecution,
Nine.
PW9. The prosecution has so exhibited another entry, general diary entry number 89 of even date, comma, recorded at 12:40 PM. So stop. As per the said entry, comma, the IO PW9 along with staff proceeded to Abhoypur village to investigate the matter as mentioned in ZD general diary entry number 88. Full stop. Para, subpara. From the above evidence stock materials, comma, it goes to establish that it was around 12 noon on 4/10/2015, comma, the factum of death of Mrinali Orangia was came to the knowledge of PW2, comma, and Moina Orangia, the younger son of the accused and the deceased. Full stop. Any other supporting evidence?
My lord, Sanjeev saw it.
Okay, so what is he says? PW3, comma, Pankeshwar Gogoi, who is also an inhabitant of Abhoypur Gaon, comma, deposed to the effect that he got the information regarding assault and killing of Mrinali Orangia from PW2, comma, Mukut Gogoi.
My lord, PW5 says that she informed Mukut Gogoi and Tankeshwar about the incident.
Huh?
PW5 says she informed to Mukul Gogoi and Tonkeshwar about the incident. When
No,
Moina informed her,
PW3 is saying that I got information from Mukul Gogoi. We'll come to that, but he says I am got the information from Mukul Gogoi. The conclusion to Bishop Innova, it is established as a question. PW5, Pallavi Hunwal deposed to the effect that she got the information about the death of Minali Orangia from her son, Moina Orangia at about 1 p.m. on the date of occurrence. First of, on receiving the information, C, PW 5 stated to have informed about the incident to PW 3, Tonkeshwar Gogoi. First of, well, perhaps it is established at around so and so. Absolutely. From the exhibit 13 within bracket 1, ZD entry number 89, it is noticed that the police personnel proceeded to the place of occurrence at 12:40 p.m. Post of PW5 also stated that it was after an hour from 1 a.m. The police personnel arrived at the place of occurrence. Post of para. The prosecution witnesses had also testified about the place where the dead body of Minali Orangia was found. Full stop. According to PW3, the dead body was lying in the house compound of the accused person, and he saw cut injury on the face and several parts of the body of the deceased. Full stop. PW4 testified to the effect that the body of Minani Orangia was lying at the back of the house of Moina Orangia, the accused and the deceased. Full stop. The informant, that's PW1, deposed that the dead body of his mother was lying in the corner of the courtyard of their house. Full stop. There is no from testimonies of the aforementioned prosecution witnesses, it is established that the dead body of Minali Orangia was found in the courtyard of the house of the accused and the deceased, wherein their younger son, Moina Orangia, also used to live. Full stop. Fair. Yes, circumstances over here. The informant, PW para, in PW1, deposed to the effect that his mother, Minali Orangia, and his younger brother, Moina Orangia, used to stay in the house with his father, that is the accused. Full stop. He further deposed that his mother and younger brother used to report him that the accused used to say that he would cut his wife and his younger son and would go to jail. Full stop. It was at about 2 p.m. on the date of the incident, he received a phone call whereby he was informed that his mother was hacked by the accused, resulting into her death. Full stop. On receiving the information, he came to his residence and found the dead body of his mother. Full stop. He further stated that the police personnel came to the place of occurrence, PO, before his arrival there. Full stop. He further stated that when the police personnel took the dead body to the police station, he also went along with the dead body to the police station. Full stop. When he was present in the police station, the accused came to the police station with a blood-stained dao in his hand and confessed that he had cut his wife with the said dao. Full stop. PW1 further testified that police seized the dao in his presence provide a serial list, ext2, and he identified his signature therein as ext2 within bracket 1. Full stop. PW1 further stated that the DAO was a mid DAO. Full stop. It was thereafter, he lost the FIR within bracket ext3 after being written by a person in a police station. PW1 further stated that his statement was recorded under section 164 CRPC. And his such statement was exhibited as ext1. Full stop. He also identified the material exhibit, met ext1 as the DAO which the accused had produced before the police and which was seized by police in his presence from the accused person. Para, during cross-examination, PW1 stated that he did not state before the police that the villagers, no, he did not state before the IO that his father arrived at the police station with a blood-stained dao and confessed that he had cut his mother with the said dao. He denied a suggestion that his father did not confess before the police that he had cut his mother. PW2-1 also claimed ignorance about the contents of ext2, the serial list by which the DAO was seized. He stated that he put his signature on ext2 at Namru police station when the paper was blank. Para. PW2, the prosecution witnesses. PW2, PW3, had any other witness who were at the police station?
No, my lord. Only 2 and 3.
These two. Had deposed to the fact that after recovery of the dead body, they also went to the police station. In their testimonies, they had deposed that when they were in the police station, the accused came to the police station. Accused came to the police station along with a dao in his hand.
PW7 is also stated.
PW7 also. No, he is police. He is police. We are private persons, not private. In his hand. And stated. And the accused stated that he had cut and murdered his wife. Full stop. They had further stated that the police seized the dog from the accused in their presence, provide the seizure list, ext2, wherein they gave their signatures as seizure witnesses. Full stop. PW2 and both PW2 and PW3 in their evidence, in their examination in chief, stated that the material exhibit, met ext1 was the dog which was seized by police from the accused. Full stop. Stop there. During cross-examination, both PW2 and PW3 stated that they did not see the alleged occurrence. And they did not have any personal knowledge about the alleged incident. They further stated that they did not know who was involved in the crime. Full stop. They further stated that they did not state before the police that the accused came to the police station with a dao in his hand. Full stop. They also stated that they did not state before the police that the accused had admitted his guilt before the police. Full stop. They further stated that they did not know the contents of the seizure exhibit 2 seizure list. Full stop. They further testified that they could not say firmly that the MET EXT DAO was exactly the weapon used in the crime. And further stated that these kinds of similar DAOs were available in the market. Full stop. Para. The prosecution has, as noted above, the prosecution has relied on the circumstance of appearance of the accused in the police station and his with a dao in hand and his confession of guilt that he had cut his wife with a dao is a strong circumstance to prove to bring home the charge of murder against the accused. Full stop.
For PW one and PW two,
PW 1 and 2, 390.
sheet নাছিলে
আছে নেকি?
one two আছিলে
3 আছে। নাই নেকি?
one and two আছিলে at the police station.
PW 3 confess নাই হা, তো তাতে PW guilt আছে, confesses guilt, তাতে PW 3 to বাদ দিব। PW 3 to বাদ দিব। PW 2 থাকিব। এই এভিডেন্স এখন চাওঁ। First on the point of admissibility of the LS admissibility of the confession allegedly made by the accused in the police station on the date of occurrence, that is on so and so. 14/2015. Full stop. As per Section 25 of the Evidence Act, no confession made to a police officer shall be proved as against a person accused of any offense. Full stop.
Not করবেন
Section 26 of the Evidence Act has laid down has laid down that no confession has put a prohibition to the effect that no confession made by any person while he is in the custody of a police officer, unless it be made in the immediate presence of a magistrate, shall be proved as against such person. Full stop. The Constitution bench in Carter Singh has considered the provisions contained in Section 24 to Section 30 of the Evidence Act and it has been observed therein as under is 723. 723 does it. 828. There are 383.3 এইখিনি Carter Singh মানে 1994 3 SCC 569. By a line of decisions, by catena of decisions, comma, it has been explained that it has been held. No, it is a settled proposition that any confession made to a police officer is inadmissible under section 25 of the Evidence Act. And that ban is further stretched through section 26 to the confession made to any other person. Also, if the confession was then in police custody. Full stop. It has been explained that quote unquote custody need not necessarily be post as arrest custody. Full stop. The word custody used in section 26 is to be understood in a pragmatic sense. Full stop. If any person is within the can of surveillance of police during which his movements are restricted, then it can be regarded as custodial surveillance for the purpose of the section. First stop. If he makes any confession during that period to any person, be he not a police officer, comma, such confession would also be hedged within the band contours outlined in section 26 of the Evidence Act. That's been ekalagok moidim, huh? It has been held that the expression quote unquote accused of any offense unquote covers a person accused of an offense at the trial, whether or not he was accused of the offense when he made the confession. Full stop. A formal acquisition is not necessary for attracting the provision to bring in the applicability of section 25 and section 26 of the Evidence Act. Full stop. Yes. Fun. পেকেটৰ ভিতৰত এইকেইটা নামকেইটা পাই দিব ষ্টেট অফ অন্ধ্ৰ প্ৰদেশ ভাৰ্চেছ গংগুলা চৈত্যমূৰ্তি Noon, I guess, yeah. Versus state of Bihar. Tufan Singh versus state of Tamil Nadu. Thus, in view of the prohibition contained in section 25 and 26 of the Evidence Act, any confession made, even it is even if any confession was made by the since the confession allegedly made by the accused in the police station on 4/5/2015 before the prosecution witnesses PW1 and PW2. The same was inside the police station, meaning thereby, the confession was made within a plane of surveillance of police. Full stop. In such view of the matter, such confession of the accused that he had killed the deceased with a dao is not admissible in evidence. And the said circumstance cannot be used by the prosecution to bring home the charge of murder against the accused. This is one. We are in dilemma because we have to sit in a single bench also every day.
Well,
My brother has also few matters. We could have gone on to complete, but to do. We do not want to keep this also. See, it will go back
again,
after
tomorrow,
vacation.
can it be taken?
Tomorrow what he speaks?
This is the part 9 is the section. Oh,
I think two circumstantial evidence case. If I remember correctly.
Right.
Bis nahi kali. Kali kono. Kali do. Kali do. Release the case as part of tomorrow. Huh?
Tomorrow.
Tomorrow.
When?
We'll take up at first. Take
Right.
up. Ugoi was supposed to. Ugoi actually. Check what is Gogoi is available.
My lord, I would like to, my lord, start from this, my lord, 2014 repetition.
2014.
Yes, my lord, but we have filed affidavit in the next case. That will cover the issue same, my lord.
2014 one.
Yes, that it is WBC 2797.
Yes.
Yeah, my lord, so far as the policy is concerned, the 2003 policy has already been placed before this honorable court by the parties. I'd like to point out again, my lord, just page, my lord, 37 of the writ petition. Clause 2.3, 2003 policy.
2.3.
Yes, madam. It says, my lord, eligible unit means only units, new units set up on or after 1/10/2003 and units undergoing expansion / diversification at the same place in the state of Assam on or after 1/10/2003 shall be eligible for incentives under 2003 industrial policy incentives, provided that, my lord, regarding other criteria is there. Here, my lord, Roman 4 says regarding expansion. An industrial unit means additional fixed capital. Expansion of an industrial unit means additional fixed capital investment exceeding at least 25% of the capital investment of the existing unit or a new unit for the purpose of calculation gross value of all the capital investment made on land, building and plant and machinery of the existing unit. Existing/new unit will be taken into consideration. Expansion shall also imply an increase of at least 25% in the existing installed capacity as well as increase of additional employment of at least by 10%. Then, my lord, 5 is regarding diversification. Says that means separately identifiable investment made by an existing unit or new unit in the fixed capital assets to set up a project for manufacturing of new product. Diversification here, it will be only for new products. Provided that the additional investment in the fixed asset is not less than 25% of the gross fixed capital, an increase of additional employment is at least by 10%. Now, regarding modernization, means separately identifiable investment made by an industrial unit involving new plus improved technology, having a definite advantage in reduction of cost of production, provided the additional investment in fixed assets is not less than 25% of the gross capital. It's regarding, my lord, involving new or improved technology. That will be considered as modernization. And, my lord, in page 40, it's, my lord, Roman, my lord, 17. Fixed capital means and include cost of land, building, including factory, is page 40. Definition of fixed capital. Means and include cost of land, building, including factory seats, godown, laboratory, plant and machinery, installation charges, and operative expenses, capitalized, electrical and such other equipment which are directly related to production activities. So this is fixed capital, which has been used, my lord, in all the other definitions. So, my lord, in 2003, it has been categorically laid down that in case of expansion and diversification of a new unit or, my lord, existing unit, they will be entitled, my lord, to get the benefit under, my lord, the scheme of 2003. And, my lord, in the definition itself, though, my lord, in the eligibility unit definition, the term, my lord, modernization is not there, but it has been defined there in the main policy itself. Lordship will see at number 6, Roman 6, 2.3, Roman 6. Because, my lord, 1 says eligible unit means only new units set up on or after 1/10/2003 and units undergoing expansion and diversification. Modernization is not there. But my lord, in the same my lord, clause, in the definition clause, 6, it has been duly my lord mentioned. Main act, my lord, in the main scheme. Then my lord, now lordship will see page 41, 2.4, eligibility criteria. New units commencing commercial production on or after 1st of October 2003 or units undergoing expansion, modernization.
Which
of-
page?
Page 41. Eligibility criteria. 2.4. A. New units commencing commercial production on or after 1st of October 2003 or units undergoing expansion, modification, diversification at the same place in the state of Assam on or after so and so shall be eligible for the fiscal incentives only against the additional investment made for expansion, modernization, diversification, or on sales of products produced in the expansion, modernization, diversification part, as the case may be, under this policy. So modernization, expansion, and diversification is now there in the eligibility criteria. Without any ambiguity, it has been my lord mentioned. Now, lordship will kindly see, my lord, the 2008 policy. Starts from page 57. Page my lord 78 is the notification by which my lord this scheme of 2000 policy of 2008 was notified with effect from 1/10/2008. Lordship will mark page 78. This is my lord relevant. Lordship may kindly mark the date. On 12th of May 2009, it was notified and it was made effective from 1/10/2008. So 12th of May, my lord, the notification date will be important, my lord. I will rely upon that. My lord, next, my lord, the chapter 4, it's regarding industrial policy introduction. There, my lord, lordship will find it,
Page.
page, my lord, 81. Chapter 4 starts at page 79. Relevant will be, my lord, 81. Lordship will see, my lord, first of all, 4.6, that is the eligibility criteria. Then we'll go to the definition. Unless otherwise specified, the eligibility criteria shall be as below. 4.6a, a unit that is engaged in the manufacture or production of goods pertaining to any industry specified in the first schedule to the Industries Development and Regulation Act 1951 is eligible. B, new units set up on or after 1/10/2008 as well as existing units undergoing substantial expansion at the same place in the state of Assam on or after 1/10/2008 shall be eligible for incentives under 2008 industrial policy, provided that for the units undergoing substantial expansion, the fiscal incentives will be only against the additional investment made on plant and machineries. So here, my lord, only the term used is, my lord, substantial expansion. There is now no mention of any diversification or modernization in the scheme of 2008. So lordship will kindly have a look at now the definition at the top, 4.5(3). It says, my lord, substantial expansion means increase in the value of fixed capital investment in plant and machineries of an existing unit by at least 25% as well as increase of employment by at least 10% and at least 25% increase in production compared to the average annual production of previous 3 years. Prior to going for expansion, the unit should be operating at least at a minimum of 80% capacity during the period of 3 previous years and prior intimation to the concerned implementing agency. So, my lord, the criteria is not the same as it was in 2003. Here the scope has been narrowed down, my lord, only to substantial expansion. Now Lordship will see chapter 6, my lord, page 85. Fiscal incentives. So, my lord, under the policy of 2008, what benefits the, my lord, industrial unit having substantial expansion, what they will get, my lord, benefit? In addition to, my lord, tax incentives, Lordship will find it at page 85, it starts at page 86. Fiscal incentives. Interest subsidy on term loan. I'm not going to the criteria and all. 6.1, 6.2, power subsidy. Power subsidy will be provided to eligible units on power tariff paid by the unit on actual units consumed for a period of 5 years from the date of commercial production subject to the ceiling given below. Then minus 6.3, subsidy on quality certification, technical know-how. The fee payable for obtaining so-and-so and fees payable for getting the technical know-how from recognized research laboratory so-and-so by eligibility will be subsidized to the extent of 50% subject to the ceiling of rupees 1 lakh per unit. Subsidy on drawal of power line. 25% of the cost payable to the state power distribution company for drawal of power line to the premises of the unit, including the cost of transformer, will be subsidized to micro and small industrial units subject to a ceiling of 10 lakhs per unit. This subsidy shall be available only once to a unit. So these are the financial incentives, my lord. Now chapter 7 speaks about tax incentives. My lord, so far as my lord, this 6 is concerned, chapter 6, my lord, regarding financial incentives. There are various departments where my lord, looking after the including power and all. And there are various corporation and all who used to give this, my lord, loans and all, my lord, including subsidies. So it has been laid down that, my lord, moment a particular unit, industrial unit, my lord, is becomes eligible, they will be entitled for these fiscal incentives, my lord. Now regarding tax incentive, there is a separate chapter, chapter 7. VAT exemption, there is 7.1 tax incentives. All eligible units which manufacture goods in Assam will be entitled to exemption of 99% of the tax payable under the Assam Railway Tax Act 2003 and the Central Sales Tax Act 1956, subject to the limit mentioned below. So, my lord, that chart provides that. Now, lords, you will see after the chart, but the fixed capital investment has not been defined in the in the clauses of, my lord, the definition part, my lord. But lords, you will find it here. Fixed capital investment means and includes. It is not there in the definition. Fixed capital investment means and includes investment in plant and machinery or additional investment in plant and machinery for expansion units and building connected directly with manufacturing process. So this is the, my lord, fixed capital investment. The definition, it has been defined in this particular chapter, in chapter 7. In case of micro industries only, cost of land purchase up to 40% of the total investment in plant and machinery can be included as part of the fixed capital investment. Now, the next para is very important, my lord. The Finance Department of Government of Assam shall be the implementing agency for tax incentives. The Finance Department will bring out a separate notification in this regard. So, my lord, so far as the tax part is concerned, my lord, they have not made any, my lord, such declaration that this will be the incentive or this will be the benefit. They have stated that it is the Finance Department who is the main implementing authority, and they will bring out a separate notification in this regard. Exemption from stamp duty or registration fees, these are additional benefits, my lord. But in case of tax, my lord, there is a specific, my lord, statement being made. A para is there that it is the Finance Department who will have to bring out a new separate notification in this regard. But in case of other incentives, my lord, be it fiscal or, my lord, this exemption from stamp duty or registration and all, there is a specific declaration that they will get the benefit. There is no such declaration that the concerned department will make out bring out a new notification. Now, my lord, again, At page 96, procedural simplification. Now, my lord, how the eligible units will be benefited from various departments? It has been mentioned here, my lord. 11.1 says allotment of land and said 11.2 is regarding power. 11.3 is pollution control board approval. 11.4 is the industries department registration. My lord, 101, my lord, page now. It's 12.4. But before that, page 100, my lord, 12.3.1. Sanction of fiscal incentives, tax concessions, financial support under chapter 6, 7, and 10 of this policy. It says all units after receipt of eligibility certificate will apply to GM of the concerned DICs for micro and small units and DICs for large and medium for sanction of fiscal incentives under chapter 6, 7, and 10 of the policy. There will have to be separate manner applications. 12.4 is regarding interpretation. The decision of the Industries and Commerce Department, Government of Assam, as regards to interpretation under this policy shall be final and binding. Now, my lord, here I would like to refer to the affidavit filed by the Industries and Commerce Department, where they have, my lord, clarified that this guideline, so far as the term modernization is concerned, it was not in tandem with the main parent policy. They have, my lord, clarified that part, my lord, in the affidavit file. Now, 12.6 procedure guidelines and application forms. A set of guidelines including application forms and procedures for getting various incentives will be issued separately. And these incentives are, my lord, those incentives which have been mentioned in the parent scheme of 2008. My lord. Now, my lord, before going to the operational guideline, I'd like to place the page 196. It is the, my lord, Assam Industries Tax Exemption Scheme of 2009. Lordship will kindly note the date, my lord. Page 196. It is notified on 3rd of November 2009. I repeat, my lord, the industrial policy of 2008 was notified on 12th of May 2009. Subsequent thereto, as per, my lord, chapter 7, the Assam Industries Tax Exemption Scheme 2009 was notified on 3rd of November 2009. May I read the relevant part? In the exercise of powers conferred under subsection 1 of section 54 of the Assam Railway Tax Act 2003 and subsection 5 of the section 8 of the Central Sales Tax Act 1956, the Governor of Assam is hereby pleased to notify the Assam Industries Tax Exemption Scheme 2009, hereinafter referred to as the scheme, for granting exemption partially to such units which manufacture goods in Assam in the manner hereinafter appearing, namely, the scheme shall be called so and so. Lordship will see the third one, my lord. The scheme shall apply to the units which manufacture goods in Assam, which are considered eligible for partial tax exemption with reference to the reference to the Industrial and Investment Policy of Assam 2008, hereinafter to be mentioned as the Industrial Policy of 2008. Now, my lord, following the scheme of 2008, in, my lord, 3rd of November 2009, the Finance Department has, my lord, issued this scheme. That is Assam Industries Tax Exemption Scheme 2009. And it has categorized, my lord, the eligible units into 3 categories. There is category A, B, and C. who would otherwise be entitled for the benefits, my lord, tax exemptions pursuant to the scheme of 2008. And my lord, in lordship will see in category B, page 197. Category B, an unit, existing unit which manufactures goods in Assam, which undertakes substantial expansion, and such substantial expansion is completed and commercial production after such substantial expansion commences on or after 1st of October 2008, but up to 30th of September 2013, and is in compliance with the eligibility criteria under this scheme. Well, this scheme, it says, will be treated as an eligible unit under category B. Substantial expansion means increase in the value of fixed capital investment in plant and machinery of an existing unit by at least 25%, as well as increase of employment by at least 10%, and at least 25% increase in production compared to average annual production of previous 3 years. Prior to going for expansion, the unit should be operating at least at a minimum of 80% capacity during the period of 3 previous years, and prior intimation to the concerned implementing agency. So, my lord, whatever definition was there regarding substantial expansion in the parent act policy scheme of 2008, it has been incorporated here in my. Now, my lord, if here I would like to place my lord next clause 4, procedure for granting of eligibility certificate for category A, B, and C. 199. This was already placed, my lord, up. Clause 4 lays down the various procedure. Then, my lord, issue of certificate of entitlement, it is number 5, clause number 5 at page 201. After the eligibility certificate, again, my lord, they will have to apply for the entitlement certificate. May I read it, my lord? The application for grant of certificate of entitlement to category A, B, and C shall be submitted in the format at Annex 7. Annex herewith to the Commissioner of Taxes. Lordship will see, my lord, the format, my lord, in which it will have to be applied is particularly laid down in this particular scheme of, my lord, 2009, that is a tax exemption scheme, not in the operational guideline. There are some formats there in, my lord, but regarding to tax exemption, we have given a separate format. Herewith to the Commissioner of Taxes in case of small, medium, large units, and to the concerned Assistant Commissioner of Taxes, Superintendent of Taxes of a micro unit. It shall be verified and signed in the same way as in the case of application for grant of eligibility certificate, white para 4.2 of the scheme. On receipt of the application for the grant of certificate of entitlement from the eligible unit, holding an eligibility certificate granted under this scheme by a competent authority. In the case of micro enterprise, the concerned Assistant Commissioner of Taxes, Superintendent of Taxes having jurisdiction over the units, and in case of small, medium, large units, the Commissioner of Taxes himself or through officer subordinate to him shall examine as to the correctness of the particulars furnished in the application and the documents accompanying therewith, and after making necessary checks, if the Commissioner of Taxes or the concerned Assistant Commissioner of Taxes, Superintendent of Taxes, as the case may be, is satisfied that the information furnished in the application is based on the information contained in the eligibility certificate granted to the unit concerned, and any further information furnished in the application or in connection with it is correct, he shall grant the certificate of entitlement to the eligible unit. The certificate of entitlement shall be effective from the date of commencement of commercial production in case of unit A, and from the date of commencement of the commercial production after substantial expansion in respect of eligible units falling under category B, and from the date of commencement of the commercial production after rehabilitation in respect of the eligible units falling under category C, and it shall be valid for a financial year. Such certificate of entitlement shall be granted in the format annexed at Annexure 8 to the eligible units of category A, B, and C within 30 days from the date of receipt of application from such units. The commissioner or the assistant commissioner of taxes, superintendent of taxes, as the case may be, shall withhold the issue of certificate of entitlement or refuse to grant it if the application and the documents accompanying it are not found to be in order and conditions laid down for the purpose are not fulfilled, or if any information furnished is not correct. So, my lord, this clause 3 is very vital, my lord. 5(3), it says that, my lord, even if there is an entitlement certificate, eligibility certificate, the commissioner of taxes or the assistant commissioner of taxes or superintendent of taxes has the power, has been given the power to withhold it. Withhold the issuing of the entitlement certificate if it is not in tandem with the scheme, or if any wrong information is furnished in along with the application form. Now, Lord, we will see the, my lord, guideline. Just I want to point out the notification date, my lord, when it was page 103 starts, my lord. One zero three starts, my lord, but one thing, my lord, when it has been approved or notified, it is not there herein. Page 171 will, my lord, give some light to this. Lord, we will see at page 171. On 25th of January 2010, the operational guideline was approved by the government. Whereas the tax exemption scheme came into force, was notified on 3rd of November 2009. Following the policy of 2008, the tax exemption scheme 2009 was notified on 3rd of November 2009. Whereas the operational guideline was approved by the government subsequently, sometimes in 25th of January 2010. So there, my lord, in the operational guidelines, the additional term, that is process modernization, product diversification, capacity enhancement, has been, my lord, inserted in the definition of substantial expansion, which is not there in the definition given for that particular term in the parent, my lord, scheme of 2008, which came later on. Now, my lord, if at all the petitioner is aggrieved by the, my lord, tax exemption scheme, which came in sometime in October or September 2009 and November 2009, they ought to have challenged it, that it is not in tandem with the guideline, not in tandem with the scheme. If at all, my lord, that guideline is a, my lord, a part and parcel of the, my lord, scheme, which cannot be, my lord, overlooked. So this particular scheme of 2000, exemption scheme of 2009 of the taxation department has never been put to challenge. On the ground that, my lord, the product diversification, process modernization is not part of the, my lord, particular scheme. Here, our stand will be, my lord, that we are following the, my lord, parent scheme. We have, my lord, prepared this, my lord, Assam Industries Tax Exemption Scheme 2009, prior to, my lord, coming up of the operational guidelines. But it has not been put to challenge in the present petition. Now, Lord, we will see section 54. My lord, levying of tax, my lord, under the VAT Act or any other taxing statute is the practice, my lord. It is a procedure, my lord. An exemption is an, my lord, exception. There is a law, my lord, laid down, settled by the Supreme Court even. Because, my lord, this tax is levied pursuant to a statute, my lord, framed under Article 309. And, my lord, in order to give some exemption, my lord, there will have to be some provision in the statute, my lord. Without that, my lord, that cannot be given by way of a policy decision also, without amending or, my lord, the statute, my lord. Here, my lord, the starting section will be, my lord, 54. Section 54, it says, my lord, exemption of certain sales and purchase. 1. Subject to such conditions as it may impose, the government may, if it is necessary so to do in the public interest by notification in the official gazette, except exempt by way of appropriate schemes or otherwise, in conformity with the provision of this act, may act any sales or purchase made to or by a class of dealers or persons specified in the said notification from payment of the whole or any part of any tax payable under the provision of this act, and any notification issued under this section may be issued so as to be retrospective to any date not earlier than the date of commencement of this act, and such exemption shall take effect from the date of publication of the notification in the official gazette for such other earlier or later date as may be mentioned therein. So, my lord, section 54 empowers the authorities to grant exemption by framing some, my lord, scheme. It says, my lord, appropriate word is scheme or otherwise, by making it effective from a particular date, but it cannot be prior to, my lord, the
Guidelines are notified or non-notified?
guideline, my lord. Lordship will see, my lord, I don't think, my lord, it has been notified. Lordship will see page 103, annexures 4.
That is the
It says, my lord, operational guideline, it's
approach.
approved.
So whether these guidelines have been notified or not notified?
That
Yes, Mr. Kolita?
That lordship, I think it should have been notified because
Is notified, that is a different ball game altogether.
I'll clarify.
my lord. Lordship.
Then thereafter, it is binding on everything, on everybody, to the petitioner, to the government, with the same force.
I'll place judgments because it is, my lord, this exemption has been given pursuant to a
So
statutory
once
provision.
once it is notified
Lordship.
in the official gazette, it becomes law.
Lordship.
That is also a subtle position. It becomes law. It is not notified, it does not become law in proper sense. Then all the constitutional provision also comes into force.
Lordship.
And constitutional provision comes into force, then statutory
Usually,
provision is subservient to constitutional provision.
lordship, in other schemes also, in the other policies also, they give a notification number only. By issuing a notification number, it's not published in the official gazette earlier. But in this case, lordship, also I haven't gone through it as yet, but I will clarify it.
See, the guidelines, if the guideline is published in the official gazette,
Lordship.
then if it is in substance, suppose we hold that it is substantial compliance of section 54,
Lordship.
then it will be that knowing everything, what is there already in the policy,
As well as the
Scheme.
exemption scheme.
but still government has notified it, then it takes a different color.
That becomes a law then,
Then it becomes a law.
so that may not be the position.
Then I think Article 13 of the Constitution will come into force.
My lord.
Perhaps Constitution. Then it will be different. Interpretation will be different.
Lordship, then I got it, lordship. In fact, lordship, I mean, in this case may not be an official gazette, but they basically publish by way of a, publish means like communicate by way of a letter.
Gazette notification will have to be gazetted, my lord.
It's not by way of gazette.
Law includes notification. And notification is to be, then it will have the force of law. And if his notification is published in the official gazette, then it is known to everybody. Then somebody has acted on it. then
My lord.
if it is in the file,
Lordship,
that is a different.
yeah, yes,
Yes.
Lordship, that is correct. But like, Lordship, otherwise
You can
also,
take your statement on record that it is not notified in the official. gazette.
that I'll check out, Lordship. That I'll check out.
Otherwise, I can proceed that
Lord.
it is not published, then it is different.
I'll
Yes.
check out.
If it is not published, I think it will be different thing altogether. But if it is published in the official gazette, then everybody, right, from A to Z in the government will be bound by it. There will be no escape route.
Well, the
What will
guidelines
prevail
came later
over
on.
what, that is different issue.
Yes. It came later on, my lord.
Huh?
It came
Whatever.
later on.
Then whatever, what is special law otherwise? Special law, general law is there,
Yes, yes.
but
sir.
special law is contrary.
Beneficial.
Then special law will prevail. And somebody having seen it in the official gazette has acted on it, then other concepts will come in.
Provision is not well known.
All these will come in. That is one thing. So we can, if we take a statement on record,
I'll verify, but in my knowledge also, it may not have been, it may not be.
that
Lordship,
published or not published.
that I'll get the instructions, Lordship. If it is not there, then I'll.
If it is not published, that will be one thing. Or something which has been published and contrary to law, contrary to the scheme of finance department.
Then
Then
That's why I
it-
will place my lord, because
then
our
which one
scheme
will
is,
prevail over which,
that will be.
that will be
my lord,
again
Again,
problem.
because our my lord scheme, it flows from the my lord power granted under section 54.
Right.
of the law.
But that
Statutory,
54 also has something that if something is scheme,
my lord.
it speaks about scheme.
Yes, scheme or otherwise. Yes.
Otherwise,
Yes, yes.
now if it is published officially, a scheme, then it will be different.
Scheme means my lord tax exemption scheme. Our scheme, my lord.
Usually guidelines and operational guidelines are not strict.
By notification in the official gazette,
My lord.
exempt by way of appropriate scheme or
Yes,
otherwise,
or otherwise.
in conformity with the provisions of this act.
Yes.
And that notification may operate retrospectively also. And the government may withdraw such exemption at any time it may think fit and proper. It is up to you. If you take I can take a statement that guidelines are not published in the official gazette.
But I'll clarify.
Anything more, Mr. Gogoi?
Yes, yes, my lord. I will continue, but I've got some judgment authorities also regarding my lord's interpretation of text.
5 o'clock,
No, my lord, on Friday or Monday. Anything convenient.
not Friday.
If
Maybe
time
on
permits, that
Wednesday.
may be there, my lord, any day I will be otherwise ready. my lord. Tomorrow there will
Give
be.
the
difficult-
relief synopsis also.
Lordship, there I will. provide.
You can put it on Wednesday,
Well,
26, Lordship.
26,
Lordship.
because I'm not sure about Monday or Tuesday. Sitting
26 is
26. okay. নামটো লিখি দিব আগৰখিনি আছে আৰু ন প্ৰেজেন্ট লিখি দিব Mr. Gogoi has submitted that he will conclude his submission on Wednesday. Date will be. We'll list the case accordingly on Wednesday. Yes, Mr. Kolita, synopsis,
also I'll produce in the other pictures. I was just got stuck up with this.
because everybody has submitted so many things.
I'll
It will be difficult to
I
recapitulate.
will definitely.
sort.
You also. Wednesday.